Good morning. Yesterday, I have discussed with you about bail pending investigation, pending trial, pending inquiry. That is curtailing the powers of the executive authority, interfering with their request. The court normally grant bail. Now, I want to discuss with you about bail pending appeal revision 482. That is interference with administration of justice. For that, first you should read 389, 186, 186. That is the first 389. Uh, 389 deals with what? If suppose the court convicts, the very same court can suspend the sentence and grant you bail, allowing you to prepare an appeal. For that, you must go through the section 389 deeply, because there is restriction that you see the convicting court, if convicting less than 3 years, or if he is convicted for bailable offence, the court may grant bail, but you have to satisfy the court. It is not that simply you have to satisfy with the ground. If the court convicts, you can, if it is below 3 years and if the offences are bailable, then you can file an application 389 class 3 stating that there are some arguable point to go on appeal, and on presentation of appeal, the accused may get an acquittal, and therefore, in between the imprisonment, confinement, in pursuance of the judgment, may prejudice his health, prestige, whatever you want, or livelihood of his dependents. All this should be stated in 389. Then the court, if satisfied, then they can grant bail under section 389. This they say 389. They say the fine amount should be uh, paid. That is no restriction. But sometimes the court insists to pay fine for consideration of suspension of sentence by the very same court. Then you see, thereafter, the suspension sentence normally be to the limited period. Therefore, you have file hurriedly before the appellate court. If it is convicted by the sessions court, then high court. If it is convicted by magistrate court to CMO court, then sessions court appeal. There 389 class 1 applies for bail pending appeal, where also you have to say that on the strength of grounds of appeal, the appellant is entitled for an acquittal. Therefore, and there is a probable cause of delay in hearing the appeal due to heavy load of the court. All this should be their ground, and you must say that you were on bail. You say the appellate court may, for the reasons to be recorded in writing, order that the execution of sentence or order appealed against be suspended. That is there. If it is punishment for imprisonment for not less than 10 years, then the notice should go to public prosecutor. Here, and the very same court should also sometimes consider that during the trial he was on bail or not. That should be one of the criteria, and his behavior before the lower court in attending the trial. Then what about revision? Sometimes the Code of Criminal Procedures restricts there may not be appeal or petty cases. Then you have to that 370 no appeal in petty cases. 376. If say that High Court passes sentence for not exceeding 6 months, Sessions Court not exceeding 3 months, Magistrate only sentence 100 rupees. There may not be, or summary trial magistrate imposes only 200 rupees. Then there will not be appeal. Then this if suppose one of the accused tried altogether, then if one of the accused was convicted more than prescribed under 376 CRPC, if he preferred appeal, you can also prefer appeal. That have to look into separately. Then arises revision. So if there is no appeal, you have to file a revision. Under revision, there are concurrent jurisdiction. That is 397. 397 deals with the power of concurrent jurisdiction. There you can file a suspension of sentence as well as on bail. It says that if the accused is in confinement, he be released on bail, on bond, pending examination of the record. That is 397 class 1. The power of Sessions Court how to deal with revision is something there. The problem is revision in appeal. You can argue as if you are arguing for the lower court. You can adduce additional evidence, additional documents also. But in revision, it is only they will see the propriety of a sentence, error on the apparent face of the record. All this would be considered. Then another provision is there. That is 424 CRPC. If suppose only fine was imposed, that may be and in default there, if there is sentence, then you can grant time to the accused not more than 30 days. Then that will be execution of bail. That is, the lower court can suspend the sentence. It is exclusively for the lower court. So these all are cases where you can seek a bail pending appeal. And apart from that, there are these all are bail. Bail means placing you under the custody of the third party sureties. But in 107 proceedings, 110, execution of bond for good behavior, that is called execution of bond. They are also with sureties, without sureties are also there. Then again, the executive orders of nuisance, this quarantine rules, direction by the executive magistrate to remove certain dangerous things, there if you may be called to execute bond. All these aspects are there in appeal. Therefore, to clear and concise my argument, I would like to take 389. 389 deals with the power of the very same court which convicts uh, less than 3 years can release you on bail. If only sentence was imposed, you can seek for time for payment of fine under 424 and get bail. And on appeal 389(1), the appellate court can grant bail. There, the 3 years restriction not be there. Then revision question arises 397, wherein if under 376 CRPC, certain petty cases there is no provision for appeal, then you can file 397 revision, and the pending revision you can get a bail. These things are the most important aspect, should be kept on your mind. And particularly so far bail is concerned, your prayer will be pending investigation, pending trial. So far appeal or revision is concerned, your prayer must contain that it is therefore prayed that this honorable court may be pleased to suspend the sentence while judgment dated so and so in SC number or CC number so and so on the file of so and so, convicting the appellant or convicting the revision petitioner under section so and so for sentence so and so so and so, then after semicolon be released him on bail pending disposal of the appeal or pending disposal of the revision and render justice. This should be the prayer. You should incorporate the entire, otherwise there may not be a proper order for your client be released on bail. Therefore, you concentrate on that, and it is very easy way how to prepare an appeal is you must go through the judgment, take out the point which are our vital point, but you have to simply say that the appellant above $60 for the appellant is so and so address for service. Then second prayer, the respondent is so and so address for. Thereafter you have to say that will be precisely easy for the court to understand your case. This way that the petitioner was arrested on so and so date for offences so and so, and on completion of investigation charge sheet was filed. If it is Sessions case and thereafter committed, and that he was tried for offences, then convicted. Thereafter you have the petitioner therefore have no other alternative than to file this appeal or then to file this revision petition against the judgment dated so and so in CC number or SC number so and so on the file of so and so, convicting the appellant under section so and so, sentence so and so, so and so, so and so. Thereafter, on the following among other grounds, then you have to grounds. Then the first ground should be the judgment of the lower court is against law, weight of evidence, all probabilities of the case, and replete with gross violation of Code of Criminal Procedure, Indian Evidence Act, or any other special act under which you have been convicted. Thereafter, it is very simply, initially you have to say, the lower court ought to have acquitted the appellant by disavowing the evidence of PW1 to PW, prosecution witness. Thereafter, the lower court ought to have rejected the evidence of Exhibit 1 to so and so and acquitted the appellant. Thereafter, you have to say that the lower court ought to have believed the evidence of DW if you have a defense witness, and if you have exhibit, I have to accepted the exhibit so and so. So the rejection, acceptance, so far exhibits and the material objects are concerned. If for evidence, disbelieved or believed. These things are. Thereafter, you have to state that the lower court ignored this point like that and erroneously convicted them. This way, you have to prepare appeal. So same thing with the revision petition also. I hope you understand This mode of preparing appeal also, which will give you confidence and a step ahead for your profession. I hope best, because today early morning you may celebrate Poki, Bogi. That means you have to forget what had happened previous days, whole year, and step up for new year. Best wishes.